of directors to the board shall be the returning officer for conduct of election of office bearers also. There will be a statutory returning officer appointed. Now, Your Lordship may kindly go to sub-rule 5. No director shall propose or second under sub-rule 4 more than one candidate for the office of president or vice president or any other office, for the office of president or vice president or any other office bearer of the society. Same Manjunath has seconded the nomination paper of the petitioner.
First respondent.
Respondent number 1. Petitioner respondent number 1 for the post of treasurer. It is also not in dispute that the nomination paper of appellant, page 120, which your lordship saw, Rajesh Gowda is the proposer.
And his seconder.
The another candidate for the post of treasurer. The another candidate for the post of treasurer is
Santosh Kumar.
Santosh Kumar. He is not Santosh Kumar. His nomination paper is at
126.
page 126. It is proposed by Rajesh Gowda. If at all, what returning officer has understood that there should not be more than one, either proposer or seconder for any post. If that is done, scrutiny, there would not have been an election because their nomination is, the proposer is Rajesh Gowda for both. Now, the learned single judge has given the reasoning that it's a case wherein I am exercising the jurisdiction under 226 in spite of alternate remedy of dispute for two reasons. One is there are no disputed facts to be decided in the case, and it is purely interpretation of the
Statute.
A rule. For that, my lord, the learned single judge has placed reliance on a judgment of the Supreme Court in Godrej Sara Limited. I will point out that, my lord. I would request your lordships to again see sub-rule 5 of Rule 14 AG. Sub-rule 5, my lord. No director shall propose or second under sub-rule 4 more than one candidate for the office of president or vice president or any other office bearer of the society, provided that if any director has proposed or seconded more than one candidate for the office of president or vice president or any other office bearers of the society, the nomination which is received first shall be considered. First aspect is, if the word used was and, I would not have any case, I would close my argument. It is not, it is just disjointed. No director shall propose or second under sub-rule 4 more than one candidate for the office of president or vice president or any other office bearer. And incongruous situation that will arise in this case is there are total number of directors
17.
for this. There will be 3 office bearers apart from, of course, let's say joint secretary or something. 3 office bearers are to be elected: president, vice president, treasurer. If minimum of 2 persons contest for the office of each one of that, the proposer seconder that would be required will be,
20.
there will be 12 nomination papers, 6 nomination paper. Nobody can be proposer or seconder. Therefore, there will be the possibility of contest being made itself will come to a negation. The rule as understood in all the cases except for the first time in this case. In the order, alternate remedy is dealt with at para 6, para 5 and 6. Please, madam, para 5.
President. The first of president, proposer is Manjan. That will be compared with one more date. Chief has folded it. Chief has folded it. Post is treasurer. Previous Manjunath has proposed, Rajesh Gowda has proposed 2 treasurer candidates. And the candidate proposed by Rajesh Gowda is declared as one candidate. Complete invalidation. So, what is a mistake pointed out to the returning officer in the case of is accepted in the case of Chetan. Chetan case is much more worse. The proposer is for the same post. He has proposed 2 candidates for the same post. Has to be decided. That's why the reason saying that no argument to Hindi is there because it is a pure interpretation of law. That interpretation cannot be left to the directives because the returning officer is as an election, the officer in the election dispute.
I am appearing for respondent number 4 and 5, my lord, the returning officer. Please.
May I make a submission, my lords? With respect to my lords, make a submission, my lords. With respect to my lords, nomination paper being proposed by two persons, one of the nominee for the post of treasurer are withdrawn, my lords. Kindly at page number 135. 134 is the copy, my lords. 135 is the typed copy. So once he has withdrawn, my lords, there was no one proposing the Santosh Kumar, my lords. Rajesh Goda was not proposing two persons, my lords. We don't know whether it has happened before scrutiny or after scrutiny. That is pertinent. That is a question of fact. That needs to be adjudicated after evidence, my lords.
No quarrel at all, my lord. I point out that it is withdrawal.
It is withdrawn, my lords.
Withdrawn.
Once it is withdrawn, there is no nomination paper in place at all. As such, my lords, their nomination paper, my lords, two persons, my lords, kindly your lordship may kindly see. Two persons who have proposed and seconded, Manjunatha ji and Satish B. May draw your lordship's attention to page number 111, my lords. Kindly, my lords. Page number 115 has seconded for the respondent number 1 hearing. Now your lordship may kindly see page 83.
115 ಮೇಲ್ ಬರೆದಿದ್ದಾರೆ ನೋಡಿ. ಅಕ್ಷರ ಹೆಚ್ಚಿನಲ್ಲಿ ಅಂದ್ರೆ ಅದ್ರ ಮೇಲೆ ಹೆಚ್ಚಲ್ಲಿ ಇವ್ರ ನಾಮಿನೇಷನ್ ಪೇಪರ್ 115 ಟೈಮ್ ಏನಿಲ್ಲ ಅಲ್ವಾ? ಕೇಸ್ ರಿಜೆಕ್ಟ್ ಎಲ್ಲ ಅಷ್ಟೇ, ಟೈಮ್ ಇಲ್ಲ. ರಿಸೀವ್ಡ್ ಇದೆ, ರಿಜೆಕ್ಟೆಡ್ ಇಲ್ಲ.
ಹೈಕೋರ್ಟಿಗೆ 17 ಜನ ಇರ್ತಾರೆ.
ಅದಕ್ಕೆ 17 ಜನ ಡೈರೆಕ್ಟರ್ಸ್, ಟೋಟಲ್ ಆಫೀಸ್ ಬೇರರ್ಸ್ 3, ಟೋಟಲ್ ನಂಬರ್ ಆಫ್ ಡೈರೆಕ್ಟರ್ಸ್ 70.
ಕಂಟೆಸ್ಟ್ ಮಾಡೋರು 6 ಜನರನ್ನು ತೆಗೆದ್ರೆ 11 ಜನ ಉಳಿತಾರೆ. ಪ್ರಪೋಸ್ ಸೆಕೆಂಡ್ ಮಾಡಕ್ಕೂ ಆಗಲ್ಲ.
ಎಲ್ಲ ಆಗುತ್ತೆ, 6 ಜನ ಪ್ರಪೋಸ್ ಮಾಡ್ತಾರೆ, ಒಬ್ಬೊಬ್ಬರು ಮಾಡೋ ಹಾಗಿಲ್ಲ ಅಂದ್ರೆ.
Instead of going for vacation of
No. It's in fact last time itself your lordships had made it clear that it would be.
Argue then now. Yes, my lords. Kindly, my lords, with respect to Rule 14AG 5, my lords, wherein the learned senior counsel had stated that if that is no director shall propose or second under sub-rule 4 more than one candidate for the office of president or vice president or any other office bearer of the society. If it is construed as that a person, a director can propose or second more than one person to file a nomination, my lords. My lords, let's take an example that there are 17 members. 3 members forms a group, my lords. If the same interpretation is given that a person can second or propose more than one person, 3 person is enough to propose and second another person with respect to one nomination, my lords. A, B and C, my lords. A, B, if they propose and second C, my lords, who is contesting for the president, and B and C would propose and second, my lords, A, who will be contesting for vice president, and A and B in turn propose and second C, my lords, who would be contesting for treasurer. If that is the intent of the legislature, my lords, then the election would be very much difficult, for the reason there will be groupism, my lords. There will be groupism.
If once it is given a wider interpretation saying that one person can second or propose more than one person, then my lords, 3% is enough to propose and second for a post of president, vice president, and treasurer. If that is so, my lords, 3 people, even 17 people can contest for all the posts. If that happens, my lords, the true intent of the legislature would be taken away. Lords, the intent of the legislature is to cut down the ineligible candidates. For a person to have a proposer or a seconder should have a confidence of the proposer and seconder. If a person cannot get a confidence of a proposer as the seconder, my lords, then he is ineligible to contest the election for the post of office bearer. Once that happens, my lords, then election, there is no question of contesting in election. They contest for the election of office bearer, they should have the trust and confidence of the directors, my lords.
For orders on Friday.
Please,
Thank you.
only this thing, my lord, that judgment.
Yes.
I may be permitted to file a judgment by way of synopsis, my lords.
Tomorrow.
In the
Tomorrow morning.
only judgment that I will point out would be, my lord, only judgment that I will point out would be, my lord, the first one. Godrej Sara Lee Limited, AR 2023, Supreme Court 781. It starts at page 1. My lord, your lordship may kindly go to para 8 at page 5. After referring to alternate remedy contentions, whirlpool, etc., etc. Ink page 5. Para 8. Para 7 and 8. Not too long ago, this court in its decision reported in so and so has reiterated the same principles in paragraph 11. That apart, we may also usefully refer to the decisions of this court in so and so. What appears on a plain reading of the former decision is that whether a certain item falls within an entry in a sales tax statute raises a pure question of law, and if investigation into facts is unnecessary, the High Court could entertain a writ petition in its discretion, even though alternate remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. I would say in the instant case, in this very decision, Whirlpool, Magath, and AB International Limited, all those have been referred to. And the interpretation is, my lord, use of the word or.
That is all.
Please.
That pertaining to, my lords, the question of fact is the one of the nominee has withdrawn his nomination. Whether he has withdrawn before scrutiny or after scrutiny is a matter of evidence, my lords. That needs to be adjudicated before the election under section 70. With respect to, my lords, the interpretation of the rule 14 AG 5, my lords, wherein they are saying that the or should be interpreted in such a way, a director should be allowed to interpret it in such a way, a director should be allowed to propose or second more than one person. That would give rise to a groupism, my lords. And I may be permitted to file my judgments along with synopsis in the tomorrow. Great.
Please.
The Lords can permission. My lords, am I audible, my lords? My lords, I appear for the respondent state in this matter. There is only one judgment which the state will place reliance upon, my lords. The judgment is Umesh Shivappa versus Angadi Basappa, my lords. I've made a copy of that, my lord. My learned friend, government advocate, Shri K.S. Harish has copies. We may be placed.
The state, my lord, respond number 4 and 5.
Yes.
He wants to place a decision on record, my lord, which speaks about the alternative remedy. He wants to place a decision on record.
So it's already produced in the writ petition, my lord, before the
In
single.
para
bench.
3, my lords, in the impugned order, it is recorded our arguments, but the learned single judge fails to distinguish as to how this particular authority is not relevant to the present factual matrix, my lords. May I draw my lords' kind attention, my lords? It's exact identical factual matrix, my lords. May I read, my lords, only 3 paragraphs for my benefit, my lords, if my lords can permission.
You come physically. Not possible to hear online. After which,
Single bench produce already ಇದೆಲ್ಲ consider ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ರು.
after vacation.
Yes.
Or come together and argue. If all comes and argues, we'll take up. Otherwise, this way is not possible. Charlie, next.
Great.
Convey to your senior that we are keeping after vacation. Because it is not possible to hear in this fashion. After it is over, somebody argues, comes and argues. Ask your senior to come here and argue physically. We are not accustomed to listen the matter in this fashion, piecemeal and the way you like. Somebody argues from here, some from here. That is not the way.
Lord,
Argue
place-
systematically
Understand.
if you want to argue. Yes.
Obliged.
My lord, but for producing the judgment, we are not making
Whatever
any
you want to
submissions.
do after vacation now.
Very well, my lord. I'll do it.
Or come on 2nd of,
Very well.
just wasting the
Apologies,
time.
my lord, I was not even aware.
1 of para 5, 1 of para 5. My lords, when there is appeal proceedings pending from the arbitral award, the respondents had
That's
filed
right.
a petition.
That's right. Appeal is dismissed. That is not
No,
being mentioned.
after the appeal is
Appeal
dismissed, also I filed another petition. When
There's
the
no stay. Appeal is
May
dismissed.
not be a stay.
They have lost the award.
May
They have-
not be a
award is in
stay,
my
my
favor.
lord.
Section 34 is in my favor. They
They have
lost
not
that.
even
Now
filed
section
execution
37.
proceedings and
I
they
am
want to
filing.
file new
They have
petitions.
repeatedly obtained conditional stay orders from this honorable court, even
Whether
from the
there
Supreme
is-
Court, never complied with the conditions.
Whether there is a stay or not when there are appeal proceedings pending arising
Its
from the
indulgence, I
arbitral
will seek,
award.
my lord, on what
They-
persuaded the learned single judge to pass that order. There is already,
Lords, I'll make a submission on what the matter is. I'm asking for a short accommodation to
if there
submit
is
all
an
the
interim order, no
compilation.
short account.
No,
This was an,
my lords may kindly see what is the impugned order. In fact, my lord's order, my lord, may I
Persuade.
read out at para 5.
let my
It
learned friend finish.
transpires-
I'll persuade my lords that in 2 minutes, there is no reason for this interim order to
It
continue.
transpires from the judgment. In fact, the interim order is still the pendency of the
Come on 29th, if possible, we'll take up.
29th, my lords. It can be immediately after vacation. No
Immediately.
heavens
But
will fall. They have
26th
not even
Saturday-
filed
26th Saturday, I will point out 2 documents. There are allotment letters in that.
immediately after 4th June. Great. Great. Much obliged.
So passover matter, seal number 43. B.R. Vishwanath.
Appear for petition. 4 acres was granted to one Mr. Kalyan Nayak way back on 7/7/1928, my lord. Since then, the survey number has identity and all revenue records, my lord, show that it is survey number 19/2. What happened, my lord? In respect of survey number 19, in all measuring 75 acres, my lord, was owned by 41 different people. An award was passed in respect of survey number 19, wherein my name was also shown as the one of the landowners. Just I request your lordship to kindly peruse page 33 of counter affidavit filed by the respondent. It's the
So what is the contempt?
that's there, my lord. How the direction issued by the Honorable Court has not been complied with. That's what I wanted to bring it to your lordship's kind notice. That's where, my lord, entire manipulation. That's where it which is affecting my personal rate. That's what, my lord. In spite of direction, my lord, they have once again resorted to the same old. That's what I request your lordship to kindly, for a moment, my lord, peruse para 7 of page 33 of the counter affidavit filed by the state, my lord.
What is the direction to be complied with?
There, I request your lordship to kindly peruse page 3, internal, that is page 11 of my petition, my lord. There, my lord, I had filed a writ petition seeking a direction, my lord. In this writ petition, the petitioner has sought for direction to the respondent to specify in the award notice dated 11/7/2022 in respect of the extent of land that may be acquired by the respondent authority along with the all existing trees, borewell, etc. in the award notice. Same award notice, my lord, has been once again confirmed by them without specifying my extent that has been acquired under the said notification. That was the grievance, my lord, there wherein a direction was given to them to specify my survey number 19/2. Otherwise, my lord, 75 acres of land in 19 is acquired. My name is shown without showing my extent, without showing my correct identity of the property. That's where, my lord, I wanted to just your lordship to kindly peruse page 33. It will throw some light on the entire issue, my lord. Just, my lord, there what they say is, my lord, this petition filed by them before the court, my lord, while deeming the amount. The petitioner, for that is the land acquisition officer, says so, my lord, in page 33 of the counter affidavit. The petitioner further submits before the Honorable Court in respect of survey number 19, total extent of 75.5 acres guntas, out of 2 acres, 15.5 acres has been acquired. So and so, they say, my lord. When there is a specific direction to earmark my survey number 19 to, once again they file an affidavit before this Honorable Court stating that, my lord, they have complied with the direction. That's improper, my lord. That's my respect. Ultimately, my lord, if at all they have taken my land, I am seeking for identifying my land to show the extent, how much of extent that has been taken over from my land. When once it is my survey number is in existence since 1927, my lord, once again showing it as survey number 19 in spite of the direction issued by this Honorable Court, that's improper. That's my submission, my lord.
Yes, where is the direction?
My lords,
Where is the direction to be complied with?
lords, paragraph 4 and 5, my lords.
Read it.
Lords, I'm sorry, my lords, my file is gone down, my lords. It may be taken up at 4 o'clock. It's not.
You don't have the files.
My lords, it is, lords, I was not aware of the Passover. It has been gone. It's gone to the chambers. It may be taken up at 4 o'clock, my lords. I'll get it.
No, day after.
Obliged.
$65 to BMV Hadekar. Number 65.
None was present in both the polls, in the first session as well as in the second. In the first session as well as in the second half. In larger interest of justice, instead of dismissing the contempt petition for want of prosecution, stand over to 25th of July.
Cell number 88. Mr. Satish KN.
I appear for the first respondent. Lord, we have complied, my Lord, fully with the order. Lord, the matter pertains to granting of fully with the order. Lord, the matter pertains to granting of 2%, Lord, additional increment based on performance. Supreme Court's direction was, my Lord, to evaluate and then grant, my Lord.
He is not there.
They have been taking-
25th of July.
It was specifically posted today, my Lord, 2:30. Matter had come up a few days back because it is only that question, my Lord, as to whether I have complied with it.
He is not interested.
So number 89. Shri Martesh GS, party in person.
Lorships have noted down that first part of the compliance is undertaken. Now we have to place it before the regularization committee and passing on the communication. Tomorrow, the sitting of regularization committee is scheduled, my lords. After vacation, we are placing the case of the complainant also before the regularization committee.
Lordship, one humble submission. Still not, they are supposed to do a polygon survey in presence of us. Still not they done the polygon survey. Earlier in the before the civil court, they produced we done a survey. That is it comes under 4 acres 18 guntas, my lord. They still not they done the survey. How they can place before a committee, lordship? They not yet done. They not yet done the polygon survey, lordship. My landing question. They have to the survey sketch is supposed to place before a committee. Still, they not done the survey, my lord. Kindly requesting this honorable court to do the survey, my lord.
They are asking for time. So it will go to 18th August.
Lordship, one more humble submission, lordship. They're not doing survey because they want to do favor of the rejectant applicant. His name is Ashwath Naranam Venmuniyappa. His application already rejected by the regularization committee in 2003 itself. After that, they're doing.
File it here, maybe. Yes.
Great, lordship.